And Beal Properties versus Melissa Daly.
Daniel Landman for the plaintiff, Your Honor. I received within the last 48 hours I ostensibly from Ms. Daly, but drafted by and submitted by legal aid, who claims to be assisting Ms. Daly in this case, a jury demand and an answer. The answer referenced some attachments that were not provided, and I have an issue with these documents that were very clearly drafted by legal aid rather than by Ms. Daly. I don't know if the nature of the quote unquote assistance that's going to be provided is full discovery, whether legal aid is going to jump in 48 hours before trial. I think that there is some ethical issue with ghostwriting and claiming to only be assisting. That being said, what has been filed with the court is an answer and a jury demand. That is where we are. It's a termination case. It's not a non-payment case. I would request that as this case plays out, that an escrow order be entered requiring payment of monthly rent into escrow with the court.
Section 8 pays my rent, all of it.
So you have Section 8 and year 0?
Yes. And legal aid, it helped me file the answer, and they're still investigating.
Okay, but you're right, I understand. And here, well, pardon?
I think they need more time.
Right, but
They told me.
let me ask you. Go ahead, what did?
Okay, they said they're still investigating the case, and there are 2 reasons that Stewart is evicting me, and I have proof that the reasons is neither of the reasons is right. The first is that my dog is unauthorized, but I have written proof that Stewart got a letter, or Chandler and Stewart got a letter from my doctor saying my dog is an emotional support animal. So this proves that they have known about the dog, and Chandler okayed it. The second is that I had boxed belongings in the front room and in my room, but this is because the basement floods all the time, so I had to move my things upstairs. Have asked to fix the flooding, and they have not. I have videos of the water leaking through the walls.
Okay, so ma'am, let me ask you this. Is that contained in the answer here? What you just told me?
I think so, yes.
Not in those exact words, Your Honor, but the answer is yes.
Okay.
Although the answer also purported to claim that there was some kind of written documentation of either the emotional support animal or the approval of it. And there were allegedly attachments, and I did not receive any of those attachments. I don't know if the court.
Ma'am, do you have the attachments?
I have the letter right here in my phone
from Stewart Beal.
What do you mean?
Well, what are you trying to show me?
This is the letter from my doctor stating that I needed that she is my emotional support dog that I need.
Okay, but I thought you said there was some communication from Stewart Beal.
Chandler, I have text messages because
okay,
I guess I forgot, and Rich, the maintenance man, told him I had a dog. Okay.
I hear you. I'm just saying.
Yeah, I have text messages.
So yeah, but they're not. None of that's attached to the answer.
Oh well, I did send it to them. So I sent them all.
Send it to who?
To Jill.
Jill Bauer at Legal Aid.
Okay. So, ma'am, here's going to be the problem. If legal services, they're going to answer this, okay, to the extent that they can. And if I set it for jury, are you going to be ready to have a jury?
Yes.
You're going to do it yourself?
Oh, no, I will have legal representation.
Who?
They are giving me legal representation. Okay.
But are they?
Yes.
Did they say that?
Yes. I was on the phone yesterday with Jill. There's another lawyer that wants to take my case, and her, either one, but I'm gonna have legal representation. Derek Johnson, I think is his name, or
Who?
I think his name is Derek Johnson,
Okay, all right.
or Joe Bowers. One of the two will have it.
Okay, so here's what's gonna happen, because this thing isn't gonna go out 2 months to my next jury selection, so it may be that this gets selected in June,
Okay.
and they need to know that. So
Okay.
that if they're gonna represent and all of this is gonna happen, then,
Yeah, she told me last night, I will for sure have representation.
all right, then tell them I'm moving this out to the 31st, next Friday at 3 p.m. and that if you're going to be represented, they need to be here. Fair enough?
Fair enough.
And
In person, right?
in person. Yep. I want them here.
Thank
And
you.
I'll indicate for the record, Your Honor, that the two communications that we received from legal aid, the jury demand came from Alex Henry. The answer came from Jill Bauer.
Yes, because Alex was helping, because there wasn't enough time, because they only do the walk-ins Tuesdays and Thursdays. So I had to go Tuesday and I had to be here Friday, so there wasn't.
No, I understand, but
Yeah.
I think the point is this. There's been a jury requested.
Yeah.
There's a legal document that's been filed. You come here and there's no attorney. And
That's what I told him. I said, I really would feel comfortable if you would come.
and so would the court. But I'm gonna give a week, tell them that they need to be here.
Okay.
All right?
All right.
Thank you.
Thank you, Your Honor. That covers everything.
That's
Once
it.
again, thank you for consideration and have
Not a problem.
weekend.
Not a problem. Drive safely. You too. Have a good holiday.
Yep. Okay. Go!
Hand me my screen box.
Now go free. Rah.
John Clark versus Jameson Wilson.
The defendants on Zoom.
All right, thank you. Mr.
Your Honor.
Wilson?
Good afternoon, Your Honor. David Fancher on behalf of the plaintiff.
All right. Mr. Wilson, state your name, please, sir.
Jameson Wilson.
Thank you. All right, what are we doing on this case?
So this is a case where last week, Mr. Wilson said he had the money, but he didn't want to pay it until we put a fan in his bathroom. The fan was installed yesterday. And I would request a judgment at this time.
All right. Is that correct, sir?
It was installed. It's not been inspected by the county yet, or the township, I'm sorry.
And so what do you want the court to do, sir?
Give me a little bit more, give John a little bit more time to get, and we are all good.
Your Honor,
Go ahead, Mr.
when we spoke last week, I think we agreed that it really didn't affect the habitability of the house, but you said.
You don't
get
deal
it
with the
fixed by-
mold inside my house, so.
Mr. Jameson, first of all, put out whatever you're smoking. You're in court. Secondly, do not interrupt. I will give everybody an opportunity to speak, but go ahead, Mr. Frontier.
But you said, and not to put words in Your Honor's mouth, I think you agreed that it didn't affect the habitability, but you said, can we just get this fixed and we'll be done with it? So my client pulled a permit this week. He then had to get a contractor out. Contractor, first day he could come out was yesterday. They were there almost all day. They got it done. They have to go back and sand the drywall and paint the drywall, but everything's done. So I'd like a judgment today. So we can get this case over with. Because I think that was the plan, was get it done. And we did.
Sir, anything you want to say regarding that?
Yeah, it's still not completed. They have not finished the job. The inspector hasn't, I almost guarantee the inspector hasn't been out yet. He did not have a contractor come out and do it. He did it himself.
So if he did it himself, I guess, does the fan work?
Don't know yet. I haven't even been back to the house yet. You guys say it doesn't affect the living. I have to smell when I walk into that house because there was no fan installed over a year ago.
What I'm going to do, non-jury trial will be this Tuesday coming up, right after the holiday. what is that, 28th?
Yes.
May 28th, 2024, 9 a.m. in person. So everybody's got to be here with their evidence. I'll make a decision, I'll make a call, and that's how we'll do it. Thank you. Wenpu Trim versus William Dunleavy.
Your Honor,
Your name?
my name is Wenpu Chin.
William Dunleavy.
Okay. This is a termination of tenancy action. And your basis for terminating the tenancy?
Mr. Dunleavy just owes us $28,500 for the rent.
So is there a written lease?
Yes.
There is.
Yeah, it's gone. There's a lease that's turned over into his.
Well, okay, this is very messed up. Ma'am, how much are you saying he owes? $28,500. And that's your sole basis for asking him to leave?
We'd like to get the money back and also,
Well,
he can't pay currently and the money he owes us, then, yeah, we'd like to, it is.
okay, so there was a previous case between you guys
Yeah.
in 2015?
Yep.
Yes, Your
That was
Honor, we
right.
signed the.
I was like 12. So what happened with that case? Can you look up 15-4C? You got it? Thank you. What happened with that case?
Your Honor, may I ask my property manager to explain to you? Ryan Chin is here.
What happened with the case?
I didn't say. I paid off that amount, except there's 500 left out of about a 20,500. I was behind 20,000 and I caught up, except for 500. Haven't thought about what it would mean other one way or the other to pay that last 500 versus paying.
But you paid it.
Yes. Yep, I caught up.
I don't know why he's waving at me. Come on up, sir. What's your name?
Brian Trim. I'm Winfrey's husband, and I do the property management there. And I just wanted to answer your question more quickly. That was a consent order in 2015 that you had signed in total of $20,000 at that time, and he paid it all back, but 500.
Okay. All right. That's fine. I just saw that on the thing. So here's part of the problem. You're seeking non-payment of rent in this case. Your notice to him, well, put it this way.
Your Honor, so we submitted 2 notices. Please see the most recent one. That's the $28,500 first on that notice.
At the preliminary hearing, they mentioned something and she corrected and submitted.
Right, but, well, I don't know who told you to do that, but here's the problem. Rent is paid. Folks, the notice that you gave to the court is to terminate, is a non-payment notice. Right? That was on 4/27. Your complaint in this case, well, who told you to do it this way?
The court in Saline.
Previous judge, we had the first Zoom meeting with the judge. They're saying, we might send the second notice.
Yeah, we prepared the paperwork at Saline and they said that was correct. And then we got to the Zoom meeting and the judge suggested that there was a problem in the, so.
No, it can't be done that way. What are you trying to do? Are you trying to ask him to leave and that's it? Or are you trying to ask him to pay? If he pays, he can stay. If he doesn't pay, he's got to leave.
Yeah, that's it.
The second one.
Yes, sir. Yes, sir.
Okay. Well,
So what we,
so you can't, folks, and I don't know who told you this, and I apologize if it was somebody from the court because they just don't even get it. You can't send a notice after you filed the complaint. Okay, because what the notice does is tell him you owe this, right? And then he has that period in time to correct or do whatever, or not do anything. And then you file the complaint. You can't file a complaint and then say, oops, I got to send you the right notice. Doesn't work that way.
okay.
Okay. And again, I don't know what they said to you. I'm just telling you, it can't work that way.
Understood.
I understand, but Your Honor, the first of the wrong notice, we also attached the item that how much money it owes.
No, I know, but okay.
Yeah, I think.
Folks, but just listen, your original notice is, let's go back and look at it and make sure. The original notice that you sent to him, the one dated April 5th, is a termination notice. It's not even a non-payment notice, right? So unless you just want him to move, well, it's all messed up.
Your Honor,
Because here's the problem. The original notice that you gave to the court before whatever that attempt at a correction was, is a termination of tenancy notice, which says you just have to leave. Doesn't say anything about money. You can put that in your complaint. Doesn't really matter. It just says you have to leave. Here's the problem with that notice. The problem with that notice is his rent is on a monthly basis. And so you'd have to, on that notice, if you wanted to proceed on that notice, give him 30 days. Okay? This doesn't give him 30 days. It gives him exactly 7. So that notice is no good to do anything.
okay.
File the complaint. The complaint that was filed in this case, and this becomes important, the complaint in this case is a termination notice. So if you wanted to terminate his tenancy and just tell him to leave, you have the right paperwork, just bad time frame, and I can't do anything with it.
Okay.
So then you get to court. And again, regrettably, somebody then tells you, file a new notice because it's got to have this.
That's right.
Incorrect. You file a new notice, it does nothing because he's got to have the notice before you file the complaint.
Okay.
So none of the notices are good.
Okay.
And if none of the notices are good, you haven't, and I don't want to get too technical into the weeds, but you haven't invoked the subject matter jurisdiction of the court, which means I don't have jurisdiction to hear the case. And when I don't have jurisdiction to hear the case, the only thing I can do is dismiss it.
Well, if I may speak,
Go ahead.
the objective here was to get a judgment that registers the amount of the money that he owes us, like you did before in 2015. And he did just pay a month rent here in May. And if he continued to pay on a monthly basis and do like he did before and pay a reasonable amount every month toward the arrearage, then my wife is willing to allow him to stay. And that's
Okay, whatever, listen, whatever you guys work out, you work out. I'm just telling you, I can't do anything because you haven't filed the proper paperwork with the court. I don't have the proper things for me to be able to, I don't have jurisdiction. I just don't.
Initially, we filed 2 sets of paperwork there, didn't we?
Your Honor, so
She did.
I understand you might need to dismiss it. So if it won't work between us, so I need to restart everything from the scratch.
Exactly.
May I ask, is my second notice is correct for what we're doing right now?
Well, okay. I can answer your question, but I hesitating to answer your question because I can't give legal advice. I know that's a funny thing for a judge to say, but I can't give legal advice to either party.
Are there two submissions of two sets of paperwork initially, Judge? Because we gave both in Saline when we initially.
What do you mean two sets of paperwork?
There was one on there, two forms that we submitted. One on the normal district paperwork heading, and another one that was, I'm not sure when Pooh might remember, the second one that you submitted that itemized all of the.
I see an itemization.
Okay.
So the
But-
first one I downloaded from the mish.gov says 7-day notice to quit. So then this judge said that this is not for the non-payment. So then I just went to find the second.
Right. No, okay. I get what Judge Barr may have told you regarding your first notice because you were trying for a non-payment. And I wasn't there. I will just say he's right that it's not a non-payment, but it can't be corrected. And even if it was corrected, the complaint that was filed with it doesn't match a non-payment.
Your Honor, may I ask what would we did correctly, then you will not dismiss this case? I just wonder.
You want to know what you,
What I didn't do for this, then you would not dismiss.
so you want me to tell you how to file a complaint?
No, she's asking is
Right
this,
now, I know it's wrong, but I like to know if what I didn't do, just go back, if I didn't.
I know you want me to tell you what you did and didn't do, and I can't do that. Because that would be giving you legal advice and I can't do that.
So at the end, I will know the reason why you dismissed it.
Oh, I just said why I dismissed it. Okay, I did. I can't tell you how to correct it. I can tell you that if you were seeking, and I'll say it again, I'll try. If you're seeking to just terminate his tenancy, he's a month-to-month tenant, which means he gets 30 days notice. You didn't give him 30 days notice on that document, you gave him 7 days. So on that basis, that notice is invalid. If you're also then seeking for a non-payment of rent case, which I think you were doing, the complaint that was filed in this case is the wrong complaint. So initially you had both the complaint and the notice are just wrong.
So
Right.
basically, you wouldn't accept my second notice, correct?
Pardon?
You wouldn't acknowledge the second notice.
Oh, I acknowledge it's there, but I can't do anything with that second notice. Because you have to give them the notice for a non-payment of rent very clearly on it says language along the lines of, I'm giving you 7 days to do this or do this. You can't give him that after the fact and tell him that's what he's got to do. All right. So I don't then have subject matter jurisdiction because you haven't invoked it for the court. The only thing that I can do is dismiss it. So, and I get what you may have been told. So the only thing that I can tell you, nothing in here is right. That's all that I can tell you. I couldn't, on my best day, try to make any of this stuff match that it would work.
okay, the video conference Zoom meeting, at the end of that, they indicated, or at least our understanding was that if we resubmitted that paperwork, and I think that's what she was.
No, I hear you.
Okay.
I hear what either you were told or what was said to you that led you to do it.
Right.
Okay, whether you misunderstood, whether you didn't, doesn't matter to me.
Okay.
I'm here now and I'm looking at this and you can't do that.
All right.
If I had been at the first one, I wouldn't have told you to do that because you can't do it. You can't then give them a notice after the fact.
All right, so we have to start all over again, but,
Absolutely.
and is there some sort of, that we don't have to go through the video Zoom meeting and then come?
Oh, you're only gonna see me
Oh, good.
because I have all of the cases now.
Okay, Your Honor, just one more question.
Yes.
It's possible that since we're already here, it's possible that, this $28,000, 500, Mr. Downavable is registered in the court.
I don't know what you mean by registered, but
Like I think she's meaning like a consent, like you did in the consent order previously.
I can't
Can't
do,
do-
I can't do anything.
Okay,
I don't have jurisdiction over the case.
gotcha.
I don't mind talking to you people about it, but I'm telling you, I can't do anything.
we
The
understand.
Supreme Court is very clear in their decision. If I don't have subject matter jurisdiction, the only thing that I can do is dismiss.
Okay.
That's all I can do.
Can we go now and can we file paperwork here now? Or is it too late?
No, they'd be happy to take your paperwork. Maybe. I don't know. I don't know how happy they'll be, but yeah, you can file the paperwork.
Is there anything else that you want to ask? Winfrey, is there anything else you want to ask?
No, you guys are good? Okay.
All right.
Case dismissed. Have a great holiday.
All right, thank you.
Case People versus Alec Jerome. Eric Cassidy. State your appearances, please.
Donna Tope on behalf of Caroline Jerome, who's via Zoom,
Yes.
and Alec Jerome, the plaintiffs in our case.
We have your Francina work combining with defendant Eric Cassidy. Paul Cassidy's not present today.
Okay, I thought that the parties were going to come back today with an indication of a framework for mediation through the University of Michigan Housing, whoever it was. And there was gonna be timeframes and the like. Not what I got.
No. So,
And we've already done some work to find out that would accommodate our needs.
so you're hearing both our complaint, which is case number 241C1772, and also their counter complaint that is an earlier case. And the thing that I want to know, would like to know first is, you mentioned consolidation. Would that happen?
No. Hold on. What I said is, both of these files are gonna come out to me. Whether it be a formal consolidation or not, as long as it remains in this court, I'm it. So, I mean, whether I work out of two files or one, hey.
Okay. Well, so I guess my question is one of procedure. Do you hear their complaint first, their counter complaint, or do you hear our complaint second or first?
Why does that matter for you?
Because I filed a motion for my case.
Let me just shortcut this. I'm gonna hear, if I have both files before me, I'm gonna hear whatever needs to be heard in an order that makes sense to me.
Okay,
That's how that's gonna work.
okay. So I also filed a statement on mediation.
Oh, I got it.
Okay, so I also contacted the University of Michigan Mediation Services, and I had a very good, long talk with my clients who attended the last hearing. And that statement on mediation is what we have come up with. We would like our complaint to be heard as a landlord-tenant complaint for non-payment of rent and termination of tenancy because they have not paid any rent and they have not paid any.
Okay, I get each party has their claims,
Okay.
but are you agreeing, the contract indicates that it will be mediated.
The contract indicates that either party can request mediation, but they did not do that before they withheld rent.
Does it say that they have to do it before they withhold rent? That's not what I read.
You gave me a really wonderful, precise, and pointed statement on good faith. We are convinced that any mediation would not be met with good faith based on all of the interactions that have occurred during the entire time that this situation has existed.
Let me stop you. They request mediation, which I think they have. And as I read the contract, when either party requested, it should happen. What would you, after you get finished saying everything that you're going to say, what do you want me to do?
I would like you to hear my motion.
So what you want me to do is ignore the contractual language of the lease and just do it your way?
I think they ignored the contractual language of the lease. They contacted an attorney and the attorney represented them, Paula, and them at our hearings.
Are you talking about Ms. Navarre?
Mr. Doug Lewis.
No, Mr.
Doug,
Lewis.
okay. And
that, to me, was that they were not following the language of the
okay,
lease.
so hold on a second. I don't even know why I'm going through this, because do you want me just to order mediation? Because I'll just order it. And then we don't have to go through all of it. And I thought the parties, when we left here the last time, I thought the parties were going to look into the process of mediation because we were looking at, you wanted something quick. And I think Ms. Navarre said that she would contact and they were going to figure out how fast they get it. And that's what we were going to come back for. I set this basically as a check to make sure it just didn't linger out there and try to develop a time frame for how this would occur. That's why that's where I thought we were. And then I get this statement basically saying you don't want to go to mediation. And that doesn't make any sense to me because the contract says that. I think both parties agreed that.
Well, I think they voided that part of the contract when they went to an attorney.
My goodness. When they went to an attorney?
They got an attorney. They did not go to mediation. They did not request mediation. I did not request mediation. Either party could request mediation. They did not request it. They hired an attorney and bypassed it. So, yeah, if you order mediation, we will definitely comply.
Well, here's what's going to really happen.
Hey.
Here's what's really going to happen. If I order mediation, I'll order mediation. Otherwise, what's going to ultimately end up happening once everything's in place, you're going to be in mediation with me, which is just mediation with a hammer. So, it's going to happen one way or another. But I guess my issue was I thought that's where we were. And that's now not where you guys are.
Well, we haven't really
You're on the
consulted.
lead there.
No, I know that when I said you guys, I was not including you. I was not including that side of the room. I'm sorry. Why don't you want to go to mediation?
We have serious reservations about all of the things that have been said to you during the beginning of this.
Okay, everybody has
We're gonna
said
be
all kinds
good
of things.
faith, that we're going to be met with good faith. We have serious doubts about that.
Okay. You have serious doubts about that? They, I'm sure, Harris will have serious doubts about that. I gave my admonishment, thinking to both parties, but also based upon what I had already seen here. I gave my admonishment that all the parties should be acting in good faith. Plain and simple.
And I did tell you that that clause is written in our lease because before anybody goes to an attorney, if there are issues, both parties.
Does it say that?
It does say that in the lease.
Says
Before
what?
Before the issues are under litigation. It says.
Okay, the fact that somebody goes to an attorney doesn't mean it's in litigation.
Oh, yeah, because he appeared at the hearing on my summons and complaint. So that, and we were then sent to you. The lease says, and it's on 37 or 34, no. It says, a mediator can't, if communication between tenants and landlord breaks down. There was no communication. He told me the night before rent was due, he was withholding rent, and he withheld rent since then. And before, if communication between tenants and landlord break down, a mediator can assist the parties in voluntarily reaching a mutually acceptable settlement of the issues in dispute. There were no issues in dispute. We had no knowledge of why he was withholding rent. He just said, we're withholding rent. And he said his wife had retained an attorney.
What is your reluctance to go to mediation?
Oh my gosh, because they have withheld all of the rent. In landlord-tenant cases, only the most catastrophic situation allows for that.
That's not true.
Well, that's
just not true. Oh my gosh. I mean, no, don't say, oh my gosh. You say, oh my gosh, one more time, I'm going to find you in contempt, and then we're going to really have a problem because that's disrespect.
I mean, no disrespect. I'm really saying, oh my gosh, to myself. I'm sorry. I did not intend it for you.
So, look, I don't, here's what I don't get, okay? Just from a practical sense. If you go to mediation and the parties with a mediator try to work out whatever the issues are, right? If it doesn't work, you're here. But the issues typically, when cases are sent to mediation, the issues that are involved get narrowed and they get clarified. And that's where then, when it comes back to the court kind of enters into it, and it's much clearer of what you're dealing with. So there's some benefit to it, or can be some benefit. If you're looking for some expedited process, I don't think that's going to happen. I'm looking at this file. It's not going to move. The period of mediation is not going to make this file move any faster here, if that's what you're looking for.
No, we're not. What we're looking for is some kind of financial certainty that you had mentioned escrow, and my motion is to escrow the amount in arrearage. I know you said that you are capped for $25,000 in landlord-tenant cases, but I'm wondering if the arrearage is more than $25,000.
Well,
are you able to?
If you're talking
that amount?
I'm not going to even answer that question. I mean, I'm not capped at the $25,000 limitation is really on the money judgment. On the possessory judgment, it could be whatever number, but in terms of a money judgment, that's where the limitation goes in.
Okay, well, I don't know the fine points, and so I was asking if we, in our motion, we ask that the arrearages be escrowed, and if that happens, we would
Okay, so first of all,
participate in mediation.
no. I don't know how you think. I don't know what you're negotiating against. I mean, I just don't. You're negotiating saying, well, they got to do X before we're going to do Y.
Well, if it's held in escrow pending the pendency of the case, and we go through mediation and we come to some kind of an agreement, then what was escrowed would pay whatever we come up with in mediation, which could be something less, and they would get the rest. But how do we just keep adding the arrearages on? This was, close to over $32,000 of unpaid utilities. How can unpaid utilities be mediated? They use them. They lived in the house. They've enjoyed the heat. They've enjoyed the electricity.
You're asking me a hypothetical. I can't answer that.
Well, I get, yeah.
There's no way for me to answer that. Certain things can be mediated. Certain things I think that maybe shouldn't or can't be mediated. They happen to be mediated and have success. I mean, I don't know.
And so we go into June 1st is coming up.
How much is monthly
They
rent?
pay nothing?
A month.
Yeah.
Well, ma'am, first of all, and so when you say they pay nothing,
No.
it's not entirely true. If you are requesting an escrow order, I will consider that.
Okay.
But not an escrow order that's in compliance absent certain circumstances, because you're asking me to go back and tell them to put money into escrow. Usually escrow orders, except under the most extreme circumstances, are prospective.
Which they probably should have done instead of withholding all the rent. If they had problems, they should have done that. But
I should have stayed in bed today. I can tell you, they can say you should have done anything. I don't know what you want me to do with that, about what they should have done.
I'm, Your Honor, I'm thinking out loud, and you have been very good. You have been very patient and with your comments that all contain a nugget of information for me when you are telling me that I'm not making any sense and that this isn't, I thought we had it all set.
So that's getting across?
Some things are, yes, it
Okay,
definitely
okay.
is, but so that's what I'm thinking out loud about is the small little crumbs that you have put out that I am trying to follow.
Okay, so let me
to
ask
the
you
cottage.
Yeah. If I order escrow beginning June 1st, will you go to mediation?
Oh, yes, absolutely. We are
Okay.
so worried about the finances.
Right, everybody's worried about their finances. But she has her hand up. Your client wants to say something. I don't know.
Your Honor, just to say, the reason after speaking to my brother, we resisted mediation is because we had this house, we're very new. This is our first house we've ever rented. And Donna is very by the books, and she insisted that we do everything, and we worked and we got it ready, and we had it inspected. We had it inspected twice and it passed. So when the tenants suddenly started withholding rent and very unclear as to why, then it was a lot of money and it didn't really build the trust between us for mediation. So I think I don't need you to do anything. I just wanted to state that. I don't need to interrupt the court. You guys know what you're doing. But I just wanted to say that that breach in trust has really affected this investment that,
No, I got you, but
okay,
ma'am, I'll just tell you, part of the reason I have to do this every day is because there's a break in trust between people. So I get it.
Yes.
Okay, so I mean, I get it for various reasons.
All right. I just wanted to say that. Thank you for hearing me.
Thank you for listening.
All right. Ms. Novar, what would you like to tell?
I don't even know where to begin, Your Honor. In addressing the mediation issue, you have been fully informed, but I hear the court going in the direction of ordering mediation, which is what we want. In August 31st of 2021, my client emailed and told the landlord they were holding rent due to no effects. That's in writing. And they told the landlord that they were hiring notice. They've got things not looking from May for the public, etc. Air conditioning is not working.
Your Honor.
So why are you interrupting?
Because you did not allow me to address those same things
but
the last
hold
time
it,
you brought
Mr.
them up.
But hang on. You expect me to have Ms. Novar, she sat there patiently saying nothing while you went on about mediation. Particularly, it seems to me that what she's addressing right now is your, I'll call it an accusation, that they didn't tell you anything and that's why mediation shouldn't happen. She's I think that's the issue she's addressing. She's saying, look, they told them, and this is what they were talking about the defects.
His email to me said, we are withholding rent, period.
Your Honor, it's our exhibit 4. It doesn't.
I know.
It doesn't say that. Your Honor.
Yes.
This is the strangest case I think I've ever been part of.
Well, you should come to my world sometime. But go ahead.
The point of the matter is that our clients withheld rent. They told them why they were withholding rent. Those still issued, and then they paid it in December. They had a family a very tragic event occurring with his wife, one of the tenants. So they had to go to Houston for treatment and surgery. And so they just said, we're gonna pay it. Let's hope when we get back, these things are taken care of. When they got back, not only were the things not taken care of, but now we have a mice infestation. They refused to do anything about the mice infestation. They called Terminex themselves. So they've in good faith. They paid their rent, hoping that they would see change, and they have not seen change. We're still dealing with the same issues they've been dealing since June of 2023. I think it's not number one, and number two, I think it's unreasonable to ask for back rent for the reasons the court. Not only that, the court rule doesn't allow it. 4.201. I-2 says it should be escrow, future escrow.
And just so that we don't have to worry about that, the only time that I ordered that's why I said it to extreme circumstances, I use what equitable powers this court does have over these cases to order that held. I don't see that here at this point.
So then at this point, I guess we're asking the court, and we have an order proposed pursuant to the lease. We're asking the court to order that the parties mediate. We have found out from University of Michigan, they can call their program now, they're happy to mediate, and they can do so. Very quick order, within a week or two, I think we could probably get into them.
Within a week, really?
And we asked for mediation way back in September, and then Mr. Cassidy again in writing asked for mediation on January 27th, I believe it was. So we've numerous times have asked. I think their position is once they hired an attorney, it means they don't want to. Which is ridiculous, and the lease doesn't say that.
Yes.
So I would ask the court to enter an order for mediation. Did the court want to address the other issues as far as consolidating the case and then the jurisdictional $25,000 issue?
I think my thought, quite frankly, was we were going to get it to mediation. Those issues were going to kind of be held off, seeing if it could be resolved at this level in mediation. That is how I envisioned when I left last week that this was going to proceed in that fashion. I thought everybody was on board with that. Okay. Is there anything else you wanted to say?
Just that if you allow escrow, prospective escrow, can we at least get an order for the payment for the unpaid utilities, electricity and gas that now are $3,418.78.
Look, folks. All right. I realize that there may be some financial pinches and strains. I get that. But every time I ask a question, I'm not going back to that issue. Just not.
So mediation is going to include the rent, the utilities.
It's going to include all issues.
And the court costs.
It's going to include all issues.
Okay, will you formally, do I prepare an order for you to sign about prospective escrowing?
Well, it's just called escrowing, but can I see, have you seen the order prepared by Ms. Novak?
No.
My client sent to me right before court. So
Pardon?
this is just the order for mediation.
Yes.
This is just the order granting mediation. So, I mean, we will sign this. We also.
No, okay, you need to understand something.
Okay.
Well, I don't, I don't know what other courts do entirely, but if I'm going to order something, I'm going to order something and I'm going to order something else, but I'm not doing this. We will agree to this if.
We just need a little certainty.
Certainty of what?
Somewhere down the road, these people who have been underwriting their residence for.
Look, I have no reason, and that's what I'm talking about. I have no reason to believe that one party isn't going to do what they're supposed to do or that another party isn't going to. I don't have any basis for that. And I think I was indicating that to the parties the last time. I'm going to assume that people will act in good faith. It's really as simple as that. And so here's the other thing that I'm going to order. So hopefully we can make us more problem. I'm inclined to sign this order for mediation. All right. Do either of the parties have a time frame they believe for the length of mediation and timing? And what I mean by that is usually when we're sending, this one's going to be unusual, certainly. When we send cases off of the summary proceedings docket, I indicate that mediation should conclude in 45 days. The parties can then, of course, come to me and say, well, we're close to doing whatever. And so can we continue? And then I will make a decision as to whether or not it moves. So that's typically how it works. And so I guess, do either party have a suggestion as to how long the mediation process should last.
I also talked with them, the University of Michigan, it's not on, what is it called? On site, on campus?
Off-campus housing program, which is what's contained in the lease, which is here. It may have some new name.
Right.
As long as it's whatever.
And I was told that, yes, we would be able to be heard within a week or 10 days. I would guess that if we set 3 weeks from today, and then if mediation is going well and we need more time, we can come back and ask for that. Or come in and present the result of mediation.
All right, here's what I'm gonna do. Parties, I'm gonna sign this, we're gonna do 2 things. I'm gonna sign the order for mediation. The parties are to cooperate in mediation. I'm gonna add one thing to this order, and that is that mediation to conclude by, and I'm gonna put June 21st, 2024, unless otherwise ordered by the court. So that's the first thing that I'm going to do, and I'm going to sign this order. So now this case is headed to mediation. I'm also going to enter an escrow order. In fairness to the parties, here's what I'm going to do. People can be upset with me if they want. I'm going to order that escrow will start May 15th. Okay. No, May 15th. No, it's okay. If you want to get up here and order here, you want to. I'm just saying, if you want to do this.
It looks better on you.
So we're going to start escrow May 15th, which is going to then require that plaintiff post 2,000, if monthly rent is 4,000, you need to post 2,000 in the court escrow for the month of May. 4,000 would need to be posted for the month of June and each month thereafter that the matter is proceeding. Make sense? All right.
My question is.
Yes, ma'am.
Utilities go month to month. I have given them the utility bills. Will we be able to escrow the utility bills? If they're going to be under mediation going forward, not going back.
Let me just ask this. Average utility bills per month, what utilities are included?
I included the most recent invoice and.
Well, I don't. Okay, first question.
$340 was due on
Can you let me
May
get
1st.
my question now? What utilities are we talking about?
Electricity and gas.
Is that all through DTE?
Your Honor, as I understand it, this is very odd again, the utility, my client's never seen the utility bills.
I've sent them all. I've sent them all.
He tells me they've requested them and they haven't even seen them.
They were sent with every invoice.
Yeah, I requested them in January, February. It's the first time I've seen them. Yes, I've seen the bills.
Okay.
I've seen cars.
So,
We need to see all the invoices, the bills.
well, but hold on, folks. Yeah, I mean, and that will at some point happen. But it's just gas and electric.
Yes.
It's all DTE.
Yeah.
Right?
Yes. DTE. There's no water, no sewer.
Okay. So then, are they, who's paying the water?
We, in the lease,
That the landlord's paying the water?
we keep them in our names so there's no transfer fee and to ensure that there's no shutoffs for whatever reason. And then I bill with the rent on a monthly basis.
Bill what?
The amount of the utilities from the past month.
Okay, and so what I'm asking is what utilities are you billing for?
Just DTE and
Okay, listen, just listen to my question. Water, no, just listen. Water is basically paid for by the landlord.
there is no water bill. We're on a well.
That's all you needed to tell me. You're on a
Okay.
well and septic,
Yeah,
right? So there is no water.
that's what I said. I did say that at the beginning. There's no water and no sewer.
Okay. And apparently I misunderstood. All right. So the only utilities, let's just boil this down, folks. The only
Yes.
utilities are DTE. Every utility that would need to be paid for by the tenants is DTE. Okay, so, and I don't have a problem escrowing part of, or the utilities. However, what's the average utility?
The average utility bill when they are in residence is about $340. 320, 363. That's the last 3 months. That was ending 4/9 and due 5.
Okay, all right, but here's the thing.
Okay,
And this is gonna be part of what the problem is. I'm assuming these bills go up in the winter.
yes, we do not pay a budget. We pay as they occur. But it's AC. So, the heat in the winter offsets the AC in the summer.
Do you have the utility bill amounts for the last 12 months?
Yes,
Okay. So with those bills, what's the average?
I don't have.
You don't know. All
No,
right,
no, no,
so-
I know, I got the total and I can divide by 1, 2.
What's the total? What's the total over the last 12 months?
11 into 2,571. $230, $240 a month, average.
What'd you just do?
I just divided the total.
Give me the total amount that you have right there of what you're saying the
Okay,
bills
the
are.
bills that have been unpaid are $2,571.64.
Okay, great. And that is over how many months?
11.
Give me
$233.79.
233.79. Okay.
We dispute that. They paid some of them. I don't dispute that number. I would also remind the court,
Well-
landlord has $7,000 in security deposit.
No, I know, but I'm not even to that. They're not out, so I can't deal with that at this point. Well, hold on. I'll get to that in a minute. Jeez. Okay, I'm not gonna do it this way. I'm not gonna do another divide. I'm just not. So if somebody wants to appeal me on that, they appeal me on it. I'm gonna order that you are going to pay that $233.79 into court escrow for each month. You're gonna pay that full amount for May. Okay, I'm not gonna half that. I just. Okay. So it'd be for May, it'd be $2,233.70. You said 79 and
Yes.
79 cents. And then for May, it'd be $4,233.79.
I think you mean $233, not 2,000.
No, 2,000 is
No.
the rent for half of
Yeah.
the day.
Oh, sorry.
Right, got it.
Okay.
That's what I did.
Yep.
Okay. So that's what we need to be deposited. The rent or the escrow for May, you'll need to do that within 7 days of today. And then for June, it's 7 days from when it's ordinarily due, but it will be due by the 7th of
7th
each
of
month. Okay? All right. Yes.
Can I ask that you add that this continue monthly until order of the court? So that if we have to go mediation
Okay, the
longer?
way the escrow order works, it continues
Okay.
till this matter concludes
you.
or until I say
Just-
whatever.
Just,
That's the way it works. You understand that, sir?
Yes, I do.
You'd have to continue to pay. If we're here in 2027,
No.
you still got to pay it.
God,
Okay. Then I'm going to give a control date on this for the parties to come back. If there's no further requests from mediation, so mediation basically would have to conclude without anything else by June 21st. I'll set this for a hearing June 28th, 2024 at
3 p.m.
3 p.m. Yes.
I can't make that. I'm celebrating my 80th birthday up north with my family. And we start on the 27th.
Okay.
So if you make it earlier, that would be all right, because I
Well, I
think,
don't want it earlier because I do it on Fridays.
oh, okay.
And so the 21st, I'm here July 5th. Will July 5th work?
That's the Friday after the 4th. Yeah, I'll be here.
That's why it's the 5th. Yes.
I'll be here.
All right. What time?
I don't have a time yet. Well, it's the week after, so 12.
12. July 5th at 12 noon.
Thank you, Your Honor.
Okay, now let me try to address one other thing, and I really want to make more issues than we have. There's a $7,000 security deposit. Why is it 7?
Because they have permission for 2 dogs, and our policy is that we collect a dog security deposit of $500 for each dog. And so the security deposit for the rent is $6,000.
It might be an issue. Pardon?
They're very nice dogs. I've met them.
Your Honor, we have one other issue that.
Oh,
Can we raise it?
no, you go right ahead. That's fine.
And what really brought it to our attention was a statement on mediation that Ms. Tope filed. She has really made herself a party to this and a witness to all of these. We are suing her individually for defamation per se. We're suing Ms. Tope. She's made police reports, false police reports against my client. And I'm seeing a possible conflict of interest pursuant to attorney ethics that will require her to not represent the Jeromes moving forward because she is a witness and also is being personally sued. And so I don't know if the court wants that issue before us at this time, but it's an issue that I was alerted to this morning as I was reviewing for pleadings.
So I wear 2 hats in this situation. I am the landlord's agent in managing the lease. And that situation that I described occurred while I was performing my responsibilities in managing the lease. Once we had to file for, once the plaintiffs decided that they would file for withholding rent, they asked me to represent them as an attorney. So I think in all of the proceedings that are requiring the landlords to be represented by an attorney, the situation that occurred against me personally should have no bearing on my representation of them. That's denying them.
Okay. So The short answer, Ms. November, to your question is, I would like that. I won't address that today, but that would have to be raised by a written motion before the court, giving ample opportunity for Stowe to respond. Counsel, I would, and why I think it would be best that it is in writing. And I'll just say this, and I don't have the answer to it, but I think what Ms. Novar in part is indicating, you both may be talking about the same thing in a lot of ways, because if you're acting in one capacity at one point and something occurs, and then litigation ensues, it may very well be that you are outside of any claim that might be made by the defendants in this case, that you may be a witness to the proceedings, and so may be in a position where you could not proceed forth.
And that, I understand.
So, yeah, I don't, like I said, I don't want an answer to it.
No, I know.
Because I'm just saying that's the first thing that, outside of what Mr. Novar was saying, that's the first thing that came to my mind after you finished saying what you were saying. So it may be right, but I think it's probably better if that be the case, that be put in writing right before the court. And then after you see what their issues may be, ethically, you may think, yeah, they may be right. Let me do X. Or you may say, nope, I don't think they're right. Let the court decide whether or not it can be here or not. That's probably a much better way for us to proceed on that. All right. Is there anything else? Seriously? Nothing? Okay. All right. Then,
Wonderful vacation. You said you were going to have a blast.
oh, I am.
Does it begin now?
The moment I walk out to my truck. All right. So, all right, folks, you guys have a great holiday and be safe, please. Ms. Novar, could you prepare an escrow order for the court signature? To the court. Thank you.
How would I submit that? Should I email it?
Yeah, you can actually email that right to Ms. Whiteline. All right. And it will get to me. Thank you.
Yes, well.
Am I 14-day stands adjourned?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs the credit.